To say that corporate fraud is a complex area of the law would be a gross understatement. Jones Day partner Jeff Schenk, a former federal prosecutor, was involved at a very high level for a pair of headline-making matters. You'll find out which ones in a moment. He's here to reflect on his experiences and talk about what corporate counsels need to know in corporate fraud investigations and cases. I'm Dave Dalton. You're listening to Jones Day Talks. A fellow of the American College of Trial Lawyers, Jones Day partner Jeff Schenk's practice includes corporate investigations and complex commercial litigation. He's conducted internal investigations involving criminal and civil issues, specifically within the technology, artificial intelligence, and life sciences spaces. For almost 20 years, Jeff served in the U.S. Attorney's Office for the Northern District of California and the Southern District of California. Hey, Jeff, thank you so much for being here today.
Thank you for having me. It's a pleasure to speak with you.
For listeners who might not be familiar with your background, talk about yourself and how you eventually arrived at Jones Day.
Sure. So any story really needs to begin with high school debate. I was a high school debater. I grew up downtown Detroit, in the city of Detroit Public High School. And the activity that really sparked my interest was high school debate. And I went to law school because of that. I went to law school knowing I wanted to be a lawyer who talked in court. I didn't know exactly what that meant or what areas of the law gave you that opportunity. But speaking in court to a judge or to a jury always seemed to me to be sort of the ultimate goal, the thing I wanted to do with my career. After law school, I applied to both federal public defender's offices and U.S. attorney's offices. Being a prosecutor or a defense attorney, I learned was the way to get into court, especially early in your career. It was never ideological for me. Sort of, I could only be on one side or the other. It was the activity of speaking in court that motivated me. My first offer was with the U.S. attorney's office in San Diego. So I became what they call a SAUS, Special Assistant U.S. Attorney in San Diego, and just loved it. Fell in love with the camaraderie, the team, everybody rowing in the same direction, the opportunities to do trials, to speak in court, to go to the grand jury. It was what I expected it to be. I liked it as much as I thought I would, if not more. After a year in San Diego, I moved up to the Northern District of California and spent the better part of the next 16 or 17 years as an AUSA in the Northern District of California, based in the San Jose branch. The Northern District has offices in San Francisco, Oakland, and San Jose, and I spent my time there in San Jose for like the last 4 or 5 years. I was the chief of the San Jose branch. And I knew that after I finished my last couple of trials, that I would look around and decide whether it was time for me to go to private practice, what that was like. I looked at Jones Day. In fact, almost 20 years to the day when I joined Jones Day, 20 years prior, I was a summer associate at Jones Day. 20 years earlier, I was a summer associate at Jones Day's Shanghai office. And there were actually still a few people left from my time in Shanghai. So
Sure.
I interviewed at the firm. I was really excited about the opportunity to come back to Jones Day. There were folks that I was really enthusiastic about working with that I met during the interview process, and also folks that I'd known from before rejoining the firm who I was interested in working with.
Right.
And I came back to Jones Day now almost 2 years ago.
Okay, where was law school and where was undergrad? I remember seeing Michigan somewhere. Was that undergrad?
That was undergrad. I went to the University of Michigan for undergrad, and I went to Boston University for law school.
Boston U. Okay. Just for the record, no one listening to this is going to care. I grew up in suburban Detroit. I was a downriver kid, Jeff.
No kidding.
Yeah, absolutely. Dearborn,
Small
then
world.
Taylor. Yeah, I know. Sure is. Talk about, now you're in the Silicon Valley office.
I am.
Talk about your practice today and maybe a little bit about how your DOJ experience informs that, how it helps you engage.
Certainly. So I'm in a practice group called Investigations in White Collar Defense. And my practice largely involves representing corporations or individuals who are facing government investigations, often DOJ investigations, but other investigations as well, state attorneys general or the SEC, other governmental entities. And I represent corporations through those investigations when they, as DOJ would call it, are witnesses, subjects, or targets through those investigations. And I also represent individuals who are charged in pending criminal cases or individuals who may be charged by the government. So it's sort of the full gambit of white collar criminal defense. I also do some civil work now that I've joined the firm, and a large part of the practice also includes some civil litigation, and I do that as well.
I know Ted Chung's in Chicago. You guys are spread out everywhere. Do you do a lot of multinational work, or are you mostly U.S. based so far, Jeff?
I do a little bit of both. I do represent clients and have represented clients that are not based in the U.S., and then the opportunity to work with law firm partners from other offices. And part of the real joy of being here is getting to meet and work with partners in various offices. A lot of my work is not just based here in Northern California, but has taken me to other parts and other offices around the firm.
Let's talk about a couple of high-profile matters you were involved with when you were still at the DOJ. And they don't get much more high-profile than Theranos, right? And as a matter of fact, there was a recent development. But I'm imagining most people listening right now are familiar with that matter and that case and what happened and how it all ended up. But just in case, give us a short, maybe summary of what was going on there, and then what the jury eventually found.
Sure. So in around 2018, the grand jury that was investigating Theranos and two individuals at the company, the CEO, Elizabeth Holmes, and the president and COO, a gentleman named Sunny Balwani, the grand jury returned an indictment charging the two of them, Holmes and Balwani, with a variety of crimes. They were charged with two conspiracies. One conspiracy involved an effort to defraud investors. So Theranos was a startup here in Silicon Valley, and in order to fund its business, fund its efforts, it recruited investors and pitched investors for funds. One of the charges involved a conspiracy between Holmes and Balwani to defraud investors. Another charge involved a conspiracy to defraud patients. Theranos was involved in the business of blood testing, of running a laboratory and testing real patient blood. And patients purchased Theranos tests. And the indictment alleged that Holmes and Balwani conspired to defraud patients out of money, the money they paid for the blood tests. And then there were sort of substantive wire fraud counts related to each: investors who invested and patients who paid for blood tests. So there was this variety of charges related to the efforts at Theranos, both to get money from investors and to get money from patients. The trials were severed. So we tried the Holmes case first. That was about 4 months. We then took about a 6-week break and tried the Balwani case for another 4 months. The jury returned verdicts in both trials. In the Holmes case, they found Ms. Holmes guilty of the investor conspiracy. Mm-hmm. And also some substantive counts related to investors, particular investors who invested. The jury hung. They didn't reach a verdict on three investor counts, sort of investors that invested at a time called the C1 round, so a little bit earlier investor round. The jury did not reach a verdict on those 3 counts. And the jury found Ms. Holmes not guilty of other counts related to patients. So the patient conspiracy count and substantive patient counts. The jury also reached a verdict in the Balwani case, and they found Mr. Balwani guilty on all of the counts: the conspiracies for patients and for investors, and then the substantive counts for patients and investors.
Where did this all go off the rails for them? Was there ever a viable business there with real tests that had some merit in the marketplace? Did they get in trouble later by defrauding people, or was it a house of cards from the beginning? Where did this start to go wrong? She seemed like the whiz kid of Silicon Valley, right? Somewhere it went off the rails.
Sure. So what the government argued at trial was that it did not need to prove, and it didn't argue, that Ms. Holmes started Theranos. So Theranos began in around 2003. The government did not allege that Ms. Holmes started Theranos with some intent to commit fraud, that the whole thing began as an effort to defraud investors and then later patients, but rather there was a point in time when the technology was not advancing and Theranos was running out of money. And it was
Okay.
at that moment when essentially this fork in the road arrived, where Theranos could close up shop, could declare bankruptcy for a lack of funds, or, and this was what the government argued, Ms. Holmes and Mr. Balwani made a different decision, and that is to begin to make false statements to investors to get money to fund further operations. That, but for these false statements, Theranos would have had to shut down, and the false statements bought it more time, or were the lifeline to additional funds to extend the runway.
Are there takeaways or lessons here? I'm beyond the obvious, right? Don't defraud investors and don't defraud patients. But as you unwound all this, are there things that they could have, should have done? What did someone learn from all this, Jeff?
Sure. I think there are a lot of lessons learned, and the lessons apply sort of depending on from the perspective of which audience. So in Silicon Valley, a lot of the lessons that the audience, that folks take from it, involve the need of founders or startups to raise funds. That's just true, and it's been true and will continue to be true. And there's nothing wrong with startups or founders pitching investors for money. The key, though, is honesty, accuracy, integrity in those pitches. Not only in the statements that the founders make in those pitch sessions, but also in the materials. Founders will often show PowerPoint slides, presentations to potential investors. And accuracy is necessary both in words that are spoken during a pitch, but also in the documents that are shown or are left with potential investors. And here, at least in the Valley, one of the lessons learned is really scrutinize pitch materials for accuracy. The trial also included a lot of lessons about crisis response or negative media attention. Theranos, as you mentioned, was high profile. There was a lot of media attention around the company. Ms. Holmes herself sat for a lot of interviews during the course of Theranos, especially in its final years. And there are a lot of lessons to be learned from how one in that situation manages a crisis or negative media attention, what one says in response to questions that arise regarding sort of a delta between what people thought the company was and what it actually was. And when confronted with those differences, how one responds. And then finally, I think there are a lot of lessons learned for trial lawyers. The perspective at which I approached the case, trying cases with significant media attention sort of is its own beast, its own animal, from topics such as jury selection. How do you conduct voir dire? How do you pick a jury in a case that has received such significant media attention, and the strategies involved with that? How do you try a case with the attention that this case had during the course of the trial? It was tried during COVID, so there were a lot of issues involved with who was wearing masks in the courtroom and the openness of the courtroom, overflow courtrooms, a lot of issues from the perspective of trial lawyers. Someone who just is interested in how a case like that is tried also has some significant lessons to be learned.
Ms. Holmes' conviction was just upheld. You emailed me, you said, did you see this? I said, yes, I did. We'll bring that up. And her 11-year, 3-month sentence has been upheld by a court. What were your impressions of her? Do you have a takeaway in terms of what she was like?
As a prosecutor, you spend a lot of time reading documents that you obtain during the course of the investigation. So emails, communications between, in this instance, Holmes and investors, text messages, all kinds of pieces of evidence. And those pieces of evidence create an impression. They make you think that either you know someone or you know a piece of them. It's, I think, important to not ever allow that to become in your mind the entirety of an individual. There is a lot of nuance to people, and what you obtain through the course of an investigation is a picture, is a portion of that individual. But I'm not sure that I really know Elizabeth Holmes or Sunny Balwani. I can speak to you about what the jury saw. Ms. Holmes testified in her trial, so I had the opportunity to hear Ms. Holmes explain her side of the story and tell the jury why she did not believe that she committed fraud, why there were mistakes that were made, and she might do things a little bit differently now, but that's different than sort of intentionally committing fraud. And it creates a real complicated, nuanced picture of an individual, that people are more than just the emails that they send or the articles you read about them. As you sort of noted in the beginning of this question, she had the opportunity to file a full, lengthy appeal. The Ninth Circuit recently issued its opinion on it and rejected all of the arguments challenging the evidentiary rulings that were made during the course of the trial and the restitution amount that was ordered, the sentence. So I think the reviewing courts have looked at it and said that the conviction and sentence and restitution figures, all of those are going to stand.
I'd forgotten until right now that she took the stand. Did that surprise you at the time? Do you think, oh, she doesn't have to do that, she's up there? Was that one of those startling Perry Mason moments when, oh, she's on the stand? What'd you guys think?
The conventional wisdom is, and in my experience for almost those 20 years in the U.S. Attorney's Office, was that defendants do not testify. It is quite rare for a criminal defendant to take the stand. I'll say I always found that a little surprising. I think that in my experience, juries want to hear from a criminal defendant. And if I'm a juror, if I was accused of a crime, you couldn't stop me from taking the stand and saying I didn't do it. Now, there's lots of reasons why, in many cases, the right call is to not have a defendant testify. But I was surprised when she took the stand. I did not know that she was going to testify until the defense tells everyone in the courtroom that their next witness is the defendant. And she testified, and she was on the stand for a while and had the opportunity to look at the jury and, as I just said, and essentially tell them I didn't do it. And here's why you should believe me.
And she certainly had a measure of celebrity coming in. I'm wondering now, does that help or hurt in a matter like this?
That's a great question. I don't know whether celebrity helps or hurts in the end. I think that there are, for every example you can find of it helping, there are examples where it does not help. The defense in the case, if they were here, I think they would say there were already books and podcasts and articles and stories out there, and they were almost uniformly negative about her. So she was famous, but at the point of the trial, she was infamous. For fraud. And that creates a different kind of challenge than someone who's famous for other reasons. And that sort of goes back to the point I made earlier about jury selection in high-profile cases, because I think for the instances in which you can identify celebrity hurting in trials, you can also find instances where celebrity helps. Ultimately, though, in a case of this length, this trial went on for 4 months. The jury has heard so many individual pieces of evidence, so many people testifying, so many witnesses on the stand for day after day after day. What they are thinking about, what they're deciding, is the evidence they hear in the courtroom.
What about tangentially? Maybe someone's not a full-blown personality or celebrity, but what about a CEO or a COO or a CFO on the stand? Do you see that a lot? In a less high-profile matter, but what happens then? Is that strategically, is that good?
In criminal cases, the conventional wisdom certainly is that all else equal, defendants tend not to testify, whether they're the CEO or CFO. If you're a charged, indicted defendant, you don't testify. Now, that conventional wisdom has been built upon a combination of factors, including that a lot of times there are cases that involve sort of violent crime offenses, and maybe the defendant has criminal history. So the concern is that when the jury hears their side of the story, they are also going to hear some things that they've done that they're less proud of. And your CEO question, CFO question sort of more often tends to not include those clear, obvious downsides to testifying. So it's certainly a different analysis in the white collar space when you're considering whether a defendant should testify or not. But a lot of times the same result is reached, and that is that defendants are discouraged by their counsel from testifying. But my view is that is a real live question, something that should be thoughtfully analyzed in each case, because there is a certain benefit to the jury hearing the charged individual saying, I didn't do it.
Right. Move on to another matter, Pacific Gas and Electric, PG&E. Now, this goes back to the San Bruno gas line rupture back in 2010, I think. You were involved in prosecuting that matter also. Again, maybe a quick overview and what we learned there.
Sure. You're right. In September of 2010, a natural gas pipeline running under a street in a town called San Bruno, California, just south of San Francisco, exploded. It ruptured. It exploded out of the ground and caused real significant devastation. 8 people lost their lives. Scores of homes and other property were destroyed. And in that case, the company, PG&E, was indicted. We often think of criminal prosecutions as being brought by the government against an individual, that there's a person sitting in the chair for the defendant. In this case, the government, the U.S. Attorney's Office, did not charge any individuals, but instead indicted PG&E as a corporation. A few crimes were charged in the case, a handful of crimes related to something called the Pipeline Safety Act. So willful violations of the Pipeline Safety Act can be charged criminally. PG&E is in a very highly regulated space. And one of the regulations, one of the guidelines comes from the Pipeline Safety Act. So there were criminal violations of the Pipeline Safety Act that were alleged. And then there was a count related to obstruction of justice, obstruction of agency proceeding. So when the pipeline explosion happened, the NTSB, the National Transportation Safety Board, arrives on scene to conduct an investigation of what happened. You often see the NTSB on scene for an airplane disaster, and they're charged with investigating those. And the NTSB also investigates pipeline explosions. And in this instance, the NTSB comes out to San Bruno to do an investigation, not to assign blame, but to investigate what happened and to make recommendations so that the explosion like this doesn't happen again. And the government alleged in the indictment that PG&E attempted to obstruct the NTSB investigation. In the end, the jury convicted PG&E of 6 offenses, 5 of them related to the Pipeline Safety Act violations we chatted about a moment ago, and the obstruction count. After the PG&E jury returned its verdict, which was in 2016, we went to the sentencing phase. And again, when you can't put a corporation in jail like an individual, one of the results in 2017, the judge imposed a federal monitor for 5 years overseeing PG&E's operation. And we've talked a bit about the gas side. PG&E has both gas and electric, and the monitorship began as significant oversight of the gas side following the natural gas pipeline explosion. You'll also recall it was right around this time in 2017 when there were significant wildfires in that part in the Northern California area. And PG&E's electric side was involved in those. So the monitor also began to look at it and monitor some of the electric side as well. So it started as sort of a monitorship over natural gas, and then events overtook things, and the monitorship included some electric side of the house events as well.
Kept them busy. So to rewind for a second, there were safety violations. And as if that weren't enough, then the obstruction charges came about. Was the feeling there they deliberately interfered with an investigation? Did they hide information? Was it sloppy record keeping, or how? Talk about the obstruction charge a little bit.
Sure. The government introduced evidence at trial, the obstruction count, that involved the NTSB asking questions about the way that PG&E operated its natural gas pipelines, and more specifically, the pounds of pressure that it sent gas through the pipelines at, and then whether those would trigger certain tests. A lot of the trial was about leaks on pipelines and tests of natural gas pipeline to test for leaks. And there's essentially a letter that PG&E sent to the NTSB that was the subject that formed the basis of the obstruction count that the government alleged was a knowingly false letter to tell the NTSB they did not do something that, in fact, the evidence showed that they did do. So the NTSB was asking about a particular policy and was misled by PG&E regarding that policy.
Horrible situation. As you noted, people died, property was damaged. And I feel almost silly, but does something good come out of a case like this? Is oversight tightened, not just there, but from a regulatory standpoint? Was there anything learned? What came out of this, Jeff? That if there's a silver lining, maybe there's not, but do you see any positive development here ultimately?
Yes, I think so. So I mentioned the 5-year term of the federal monitorship, and
Yeah.
we would go to court on a regular basis. There, the PG&E, the counsel representing PG&E, the government, the monitor, the judge, and have discussions about the work that PG&E was doing in response to our criminal prosecution and also in response to the wildfires. And I
Yeah.
think there really were affirmative steps that PG&E was taking through the guidance of the monitor to improve both on the natural gas side of the house and on the electric side of the house. So one of the real benefits from the prosecution was the remedial efforts taken by PG&E following the conviction, especially in that period of time under a federal monitor.
Sure. Jeff, you've been really generous with your time, but I did want to, I guess, kind of open this up to maybe something a little more broad. Any big picture trends you've noticed, developments in terms of white collar investigations where it comes to crime, that sort of thing, in the dawn of a new administration and so forth? And I know things will change, but what have you noticed in your couple of years at Jones Day in terms of what's catching the attention of regulators and what corporates ought to know right now in terms of the enforcement environment?
Yeah, I think first, as you know, we are really sort of on the eve of the new priorities, especially at DOJ, not just what priorities DOJ will announce, but also where resources are dedicated. DOJ has funds to hire prosecutors and agents and to dedicate agents to investigate this crime or that crime. And we're sort of right on the eve of some of those significant decisions, not just having been made, but then seeing the implication of those decisions. So you've heard talk about a focus on immigration and narcotics offenses by DOJ. Sure. The Attorney General has issued certain memos that talk about things like charging the most serious, readily provable offense and not using criminal charges to exert leverage to induce guilty pleas. I also have noticed, and this certainly goes back to my time at Jones Day, even before the administration change, there's been a real focus on the corporate compliance departments and what the internal policies of the company encourage or discourage. When the government does investigations into companies, they are often interested in hearing, even if there is behavior that the government is interested in or is concerned about, whether that was an aberration, whether that was behavior that was discouraged by the compliance department or consistent with or encouraged. So I think that in my time here, there's been a particular focus on the efforts undertaken within the compliance departments of the various clients, the companies that we work with. But really, we sort of are on the eve of interesting times doing white collar investigations.
Well, Jeff, this has been terrific. I hope it was great meeting you, finally. I hope we get to do this again soon. It is the dawn of a new administration. It's going to be an interesting couple of years, I think. So I hope we get to do this again soon as something pops or gets interesting, you see a trend or whatever. Let's please talk again sometime soon.
Thanks so much. It's been a real pleasure chatting with you.
Thanks. Take care, Jeff. For Jeff's contact information, please visit jonesday.com. While you're there, check out our Insights page where you'll find more podcasts, videos, publications, newsletters, and other pertinent content. Subscribe to Jones Day Talks wherever you find your podcast programming. Jones Day Talks is produced flawlessly by Tom Condolis. As always, we thank you for listening. I'm Dave Dalton. We'll talk to you next time.
Thank you for listening to Jones Day Talks. Comments heard on Jones Day Talks should not be construed as legal advice regarding any specific facts or circumstances. The opinions expressed on Jones Day Talks are those of lawyers appearing on the program and do not necessarily reflect those of the firm. For more information, please visit jonesday.com.